Hello again, everybody, and welcome to the Layman's Law School. And today we have a very, very, very special episode. We are joined by our good friend and nice woman that works with us and puts up with us on the daily basis.
She's
Lindsey
a nice
McCullough.
lady.
Yeah, she's a real nice lady. Lindsey McCullough is here with us, and she is going to kind of lead this discussion today. So we're going to kind of start talking about kind of some myths that y'all may have out there, some old wives' tale, driving with no shoes, that kind of stuff, and maybe talk about that and see if me and Shawn can be stumped. We don't know the questions. We're going to do our best to answer them. But before we start, I'm always joined by my friend and compadre, Shawn Merzlack.
And regardless, she's sitting in for Chace Hawk. So we want to really see.
It's a win-win.
We want to see. We want to see the response from the viewers, from the listeners.
Listen,
because it just might be a permanent thing. If Chace wants to go gallivant,
right? Go gallivant.
Go to these weddings of family members and things, and skip this very important podcast.
Right.
We might just replace him.
I mean, everybody and everything is replaceable. That's all I'm saying. Exactly. I'm not throwing stones.
Usually I'm in the background, and so I'm usually, if you hear any laughing on the track in the background, that's probably me.
And there's not a lot of laughter. We tell some jokes that land flat. How about that? But before, Shawn's already got his drink, but I'm gonna make him.
I'm gonna have another one.
I'm about to say I'm gonna make him have a Bud Light. Anyway, now
it's like
we
being
caught
a
lot of flack in the comments when this podcast started. That was
not a political
Bud
statement.
Light was really going through it. Now Shane Gillis is their spokesperson, and everybody's, Bud Light's fine again. Hey.
Oh, did he take up? He's their spokesperson now?
It's me and Shane. We stood by what we like. It was
Cheers.
no political statements, just drinking statements.
How much is Bud Light paying you, though?
Zero. That's the problem.
Oh, that tastes like high school.
My dad says high school. That's right.
Well needed.
But to be fair, you went to high school for 12 years, so you were 27 when you graduated.
No.
Otherwise, you'd be breaking the law if you had tasted that. Which you never did.
I see your point. That tastes like college. The later years.
The later. Mm-hmm. Your junior and senior year of college.
How about it tastes like sitting on the back of a tailgate in a field listening to 80s country music.
There you go. There we go. So now you're in.
Perfect.
Well, Linz, how do you want to start this thing off, girl? Do you want to you're basically the moderator. So.
Okay. So I think a lot of times people have we all have these misconceptions, things we probably heard over the years since we were kids and as we grew up or whatever, these different things that may or may not be true. And so I thought it'd be cool to go through, I did a little research on some of the common legal myths that maybe people search for on Google and different things like that. So the first one's pretty general, but I think a good one for us to start with is you can sue for anything.
Well, not really. There has to be some cause of it. I mean, technically, you could file a complaint.
Technically, yes.
And say whatever you want in it, but it's just immediately going to be dismissed for failure to cite a claim of action. In every state, there are certain laws and legal claims that you can assert. And those legal claims each have elements that you have to assert in it. So, yes, I could say that, Lindsey McCullough called me ugly, and I'd like to sue her for $1 million, but it's just going to be dismissed. I could file it; they would accept it, but it's going to be dismissed later because it fails to actually state a legal claim.
Gotcha.
This is a two-parter for me because it is true. Yes, you can sue for anything, and I think that when you hear that, it's people complaining about the too much litigation.
Yeah.
And that's just not true. When they say you can sue for anything, yes, you, like Shawn said, you can. But here's the key that I don't think people understand is that doesn't go to a jury. You can't say, well, he's got friends in the community, and if they just get a jury, he'll give them $1 billion. It just, like Shawn said, it goes to one step in the court system, and then they immediately squash it. No one ever will hear any of it because it just fails at its face. So that kind of expression of, you can sue for anything. It's completely, while being true, but it's the system we have in place makes that completely false, right?
Gotcha. Yeah.
Well, and that's why there's lawyers, because most of the time we have a interior feeling that we have been wronged some way,
right?
And that we have been wronged, even legally. It's then that you go and have a consultation with a lawyer and say, this is how this person, this is how this business did something to me that I think is wrong, and that lawyer or attorney analyzes it and tells you whether or not there's a legal basis for you to assert a claim. Not, or that we say, just like
sorry,
we tell a lot
hurt your feelings.
We tell a lot of clients, I'm sorry that this happened to you, but there's just no legal basis for us to pursue something.
Sometimes things suck, and it just sucks. Life happens with a hurricane. There's a lot of bad things going on. That doesn't mean that you just somebody's automatically at fault, or somebody you can recover. There's all kind of legal actions. The second part of that is, when you're talking about that, it kind of goes into, like I said, too much litigation and all this other stuff. I've heard this throughout my childhood, and I say it now, is that people bring lawsuits. Lawyers don't. So you can say, well, these lawyers. The only way a lawyer brings a case is if a person comes to them and says, I need you to bring a case and file a case. And we can't make money unless we win the case in our situation.
Sure.
Other lawyers aren't going to do it on their own if they're getting paid for the case. They're going to have to be paid by somebody or some entity. So our community is the one that brings the case, not the lawyer. So if you're mad that there's too much litigation, be mad at your neighbor, not your lawyer.
Sure. I mean, and that, just like Reid said, in personal injury, wrongful death cases, we work off contingency, where if we spend 2-3 years on a case and we end up getting zero, well, all that time, resources, expenses, all that we just eat. So that's kind of a safeguard in.
Why on earth would we take a case that we don't believe in?
Yeah,
I mean, it doesn't make any sense.
We take cases that people have been injured in, people have been wronged. It's through no fault of their own. There's a at-fault party for it, and we're simply trying to recover, compensation for their injuries, medical bills, things like that.
Yep.
The other thing is, if you go to an attorney who does other types of litigation, that's a fee type base,
right?
That
pay
attorney
up front.
That attorney should tell you, well, I don't think you have a case here. We don't have a very good, legal basis for this, or you don't have the right evidence to show this type of thing. But if you want me to pursue it, it's going to be X amount of dollars, and you pay that up front. And a lot of times that is going to immediately take out a lot of the people who would be filing some type of a frivolous claim.
And I've had a couple that I've had come to me that I'm like, this is nonsense, and I tell them that. I say, this is not, it's nonsense on a lot of different levels, and then they'll offer me, well, what if I pay you $10,000? I'm like, I'm not going to take your money, because the only thing that's going to happen is I'm going to file this. We're going to lose before, like I said, doesn't go to a jury. We're going to lose because the law says you lose. And then you're out $10,000, and then you're mad at me. Like, why? I don't want to do that. I mean, that's crazy.
I tell people all the time, I said, we want to be compensated for providing a service.
Yeah, we're trying to help.
We can't provide a service to you, or we think that what we're going to do is not going to provide you any relief, we're going to tell you that up front, and we're not going to take the case, because it just leads to down the road, regardless of what you tell them up front, they're going to be upset on the back end. Even if you played the video and said, remember when I told you this a year and a half ago, that your case was going to get dismissed and we were going to get nothing? So it's better to be up front with people from the get-go. Say, sorry, this is not a legal avenue that you can pursue.
Right.
Give them some other options if there are other options out there, and part ways.
The key, I would tell to end it, is essentially the great lawyer phrase of the answer to that is yes and not yes.
It depends.
Yeah. My law professor said you couldn't even say no. You had to say yes or not yes because you could change the definition of no, and it depended. So our whole thing was it's either yes or not yes, but that's all I can tell you.
All right. All right, well, we'll move on then. So to legal myth number 2. Police must always read your Miranda rights to you. And I'm looking at you, former police officer.
You can probably answer that question. Have you ever been pulled
Detained?
over? Have you ever been pulled over for a speeding ticket or something?
Not recently, but
well, I mean,
at some point.
Did that police officer read you your Miranda rights?
No, he also wasn't arresting me. I think people are asking this question like if they're being arrested.
Okay.
Well, that's a big difference there now. I mean, now you're talking a big... That's a big difference.
Curveballs.
No, I'm saying that's a big difference in the law right there. That's you can get a citation, and then if you're getting arrested, Shawn.
No matter what, the answer is not yes, as Reid.
Yeah, that's right.
Or no. Police officers do not have to read you your Miranda rights. There's certain situations that they do.
Yep.
There's 2 things that have to be present. You have to be in custody.
Okay.
Or, detained, arrested, whatever you want to call it, and they have to be interrogating you regarding, the situation.
Okay. So when you see it on TV, when they're like arresting someone in custody, about to put them in the car, and they're reading them their rights.
In certain states, that is
to be clear for anybody who's watching, we don't. We're talking Georgia.
Well, it's
in most states, but I'm saying
it's a constitutional issue of the United States Constitution.
Sure.
But in other states, other jurisdictions, they may have a policy that
you
arrest somebody on the side of the road for DUI, you immediately read them their rights. We see that on these true police documentary type Cops and things like that. That may be their policy because they're wanting to immediately, once the person is in custody, read them their Miranda rights. That way, anytime down in the future that somebody questions them, there's no question that it happened from the beginning.
And you have it on camera. Sure. You have it all. I mean, that's.
But no, if police don't read you your rights, it's not going to get the case thrown out. If police don't read you your rights and you don't say anything that's incriminating, or you don't say anything that they can later prove that was not true, it's not something that we're going to object to.
I would say it really more goes towards what evidence can come in and not come in.
Oh, yeah.
When that happens and all that kind of play. It's not going to change the fact that the charge is still there and you're still charged with it. It at best could eliminate a piece of evidence.
Which would be the statement that you give.
Right.
And sometimes anything that flows from that statement. So if the police were to arrest you, you were to be in custody, and they were to question you without Miranda, we would then analyze that later and make a determination whether that statement was harmful to you.
Gotcha.
Obviously, if there was no other evidence and you confessed to the crime, well, then it would be a motion to suppress that statement based on your rights being violated because they didn't read you your Miranda rights that, advise you of your right to have an attorney, your right to remain silent, things of that nature. And that statement might be thrown out.
But if you got a dead body in your trunk, your statement might not matter is all I'm saying.
Correct. Correct.
That doesn't change the case.
Gotcha. Okay. All right. Legal myth number 3.
But to finalize that, the answer is yes and not yes for that one.
Perfect.
The police
I wonder if there's a pattern to this. All right, so legal myth number 3. I can remember growing up, my mom, and she still loves to do this, but she would take me into all these antique shops everywhere, all across South Carolina. And everybody's going to know when you go into an antique shop, what is the one sign that you see? If you break it, you buy it.
Please don't touch. You break it, you buy it.
So that being said, is that an absolute? Like, if you break something in a store, are you obligated to pay for it?
I'll start it. How about that, Shawn?
Sure.
The answer is yes and not yes, but more not yes. It's these broad statements. It makes it difficult, and the reason for that is that we've talked about waivers a lot. I always get on waivers, and because they drive me crazy. your rights are still your rights. You know, you're not giving up your right because there's a sign in the store that says, well, if you look at the black cat, you owe $100. It doesn't make sense, right? Yep. So if something breaks and it's not your fault, then you don't owe anything. It still has to be your responsibility. And that's not even to talk about the fact that it's like it would have to do a separate action of, let's say I broke it intentionally. They can't hold me hostage if I don't pay for it. I can I can leave now. Then they can bring a claim to say that I owe it, and that, but they have to show that I did it, that I broke it, that it was my fault, and that they had paid for it, and that they need reimbursement. So there's all these steps. It's essentially it's just skipping a lot of things. It's like you break it, you buy it. Well, that might be true, but you got to go through all these other processes before you actually have to buy it.
Gotcha.
And like I said, a lot of it, especially when you're talking about antiques, if you pick up a little antique cup and you did nothing wrong except look at it to examine it to purchase it, and it just shatters, well, you're not responsible for that. You know, they can't hold. You might have broke it. I guess it goes to, how do you define you break it? Well, I didn't break it. I picked it up.
And it broke.
You know what I mean? Yeah. So that it's like it's an overreaching term. But the laws are still the laws. If you go in there and break something, and you, even if it's not intentional, obviously, but like you could have a situation where if you break something that you still aren't liable for it because you didn't have a clear walkway. You know, the rules of premise liability still apply. So generally the answer is no, but you could be held liable and have to pay for it.
But the final answer is
yes. And not yes.
Well, I mean, and that's just the thing. I mean, if I picked up an item in a store and I knew that it was my fault, that I went to put it back on the shelf, I was the one that dropped it.
Yeah.
I'm going to pay the antique person or whatever, the shopkeeper.
The policy that should be your own personal policy.
Yeah.
And that's my own personal policy.
That's your
that's
moral
not the
compass.
law.
That's not your legal.
That's not the law.
Yeah, or if you're letting your kids, run
absolutely.
rampant in a store and they bump into a display and break some stuff. Well, I mean, it's just analyzed at the same level as, car accidents or anything. It's like, was this person at fault? Are they liable for these damages? What are the damages, the amount of the property that was damaged, and whether or not they can pay for it. You're not going to be able to call the police and have them arrested unless it was an intentional act.
You got something, if you're talking antiques, let's say something's $100,000 and a little kid knocks it over. Well, the antique store has insurance, and they're going to have to file a claim because they're not recovering from the little kid who knocked it over. So it's
well, and there's certain things that you would have a defense of.
Yeah, there's tons of defense. I mean,
attractive type, nuisance type defense. If you have a certain item that's out readily available to the public that you would expect the public to pick up and handle,
or even
it's $100,000.
You
should have something around it so that the public can't get to it. There's certain things that.
Or you have things that they say try me or pick me up, whatever. If they break, that's not on you.
Sorry.
I wasn't told how to use it. I never got looked at the packaging that says how it should be used. Yeah. That's on you. You invited that. And it's just like when you're going in there to purchase something, you are invited into the store. You're an invitee, and so the burden shifts a little bit. So they have to take care of you. They're bringing you into a potentially dangerous situation. So if you accidentally break something that you're not used to walking through these aisles, or you've never been to this store before, you can't see well, or whatever it is. Optical illusions happen a lot in stores because it's just different. They want to, like Shawn said, attractive nuisance. They want you to look up here to shop at the high price stuff, and you end up knocking something down on the bottom that cost a bunch of money. Well, that's probably, you're probably not liable for that.
Interesting.
It depends.
Still not
yes,
taking my toddler through an antique store anytime soon.
And like Shawn made a great point too, in the fact that that's what the law says. The law, and I say this all the time, the law is the minimum standard.
Sure.
Like if I do something, even if it's not my fault, a lot of times I'm like, look, I could have handled that better. I'll pay for it. I'll take the blame. Yeah. And I think that's the way it should be. The legal standard is, this is the minimum of what our community has to do.
Yeah.
Right? We don't want to get to this standard, but this is just the minimum. We want to
Yep.
be better than that.
Okay.
I'll be off my soapbox now.
All right. Legal myth number 4. You can legally use force to protect your property.
This is another
Well-
this is another dicey one. Yeah. Yes and not yes. Go ahead,
Yes and
Shawn.
not yes.
Well, I mean, I couldn't just make them all yes or no.
Well, I
We'd be
mean,
done in
no,
15 minutes.
That will explain why, but yeah.
Yeah.
If you hear some sound in your driveway at night, at least in the state of Georgia, and you go outside and there's someone trying to steal your radio out of your car, steal your car. You know, we grew up in a day where radios were actually stolen. That I don't think that happens really anymore. They just steal the whole car. Can you just put a bullet in the guy or girl? Absolutely not. There is, very strict laws that allow you to use threats of deadly force or deadly force in the state of Georgia, and that is, when you are trying to prevent serious bodily injury or death to yourself or to a third person.
Okay.
So when you say, can you use force to protect your property, if 3 o'clock in the morning, 2 guys are trying to kick down your door to do, a home invasion, whether they're armed or not, you're not even going to know. They're trying to kick in your door. You're afraid for your life, the life of your daughter, the life of your husband. Absolutely. Dial 911 if you think they're going to come in the door. You would be justified in firing rounds through that door to prevent this serious bodily injury to yourself or to others. But simply because someone walks up in your yard and steals your daughter's bike and starts walking off with it, you can't use that type of force.
Gotcha.
I'll add this kind of brings up the old wives' tale of, I know people have heard it at least in the South, of if you shoot somebody, whatever, and they're outside, drag them into your home, right?
My dad used to say that.
Yeah. So
Like drag them inside because it'll be self-defense.
Right. And there's some truth to that. Please don't do any of these things, and don't drag somebody in the house. First of all, investigators are smart. They
Forensics
know you
are way better.
Yeah, that's
than they used to
ridiculous.
be.
But the reason for that theory, I guess, is because it goes to what Shawn's talking about. Of it's got to be a threat of physical harm to you. You can't kill somebody. Just like we don't lock people up in our country because they owe money, outside of the very few things about child support and all that. But it was supposed to be you never got locked up for money, ever, ever, ever. So we don't want somebody to die over property, right? But you can still defend yourself or be in bodily harm if they're outside. If they're, got a gun pointed at you, whatever it is, and you shoot them and they're in your yard, you're fine. Now, if they're just stealing your bike and you're shooting them, that's different. But I'm saying you just have to show that they're creating that fear of bodily harm to you or your loved ones or whatever. But you just don't shoot them for a bike and then drag them in the house.
It just reminds me of a day long ago when I was a patrol officer, and on numerous occasions, showed up to calls, and it was usually elderly individuals.
Sure.
That someone was breaking into my shed, and I fired off a couple rounds in the air to scare him. I was like, sir, I'm not going to put that in the report.
Don't.
We're just going to go with someone was breaking into your shed and you scared them off. There's things like that. That can be seen as reckless conduct. Especially when you have no real threat to yourself.
The last one I wanted to mention, and you know a lot about this too. You can't set booby traps and stuff like that. Like you can't, if you know a dude's coming, like you can't put the little sticks out of the ground and stuff.
Where did this thought come from?
But I mean, I'm saying, anyway.
Man traps. They teach us all about it in law school.
You can't set man traps.
You go out of town and set it up so that if somebody goes in your front door, a shotgun
goes off.
You can't Home Alone booby trap a house.
And now, me and Shawn were what he just said about like having a shotgun go off if somebody opens your door. Like these all came from real world things
Stuff
that happened.
Yeah.
These are the laws from that kind of stuff. So you can't set guns up to go off. You can't set There was one where the sticks were out and you fell in the hole and the dude.
Oh, yeah.
Can't set up the holes with the
Yeah.
sticks in it and all that. You can't.
This is all ideas they got from movies though and TV.
I think the movies and TVs got it from
You
them.
think?
Yeah.
Chicken egg.
And war. I mean, and, like that. The Vietnam War had a bunch of
Yeah.
traps and stuff. So, yeah, you can't do that. Can't do that. Let's just stay away from there.
good to
And
know.
let's kill the myth of if a person breaks into your house and breaks their leg that you're liable. There's so many
Caveats.
variables that have to hit.
Yeah.
For that to happen, it's 1 in a trillion, maybe 1 in 100 trillion. Like it's just not the truth. You got a way better chance of winning the big lottery than you do having somebody break in your house if they broke in every night and hurting themselves and them to be able to recover, unless you have a man trap.
Unless you have a man trap, because I mean, literally the standard.
Is that the legal term?
Well, I mean, that's what they call it. Yeah,
all the case law.
But we're always looking at, what is the legal duty,
Mm-hmm.
whether that duty was breached.
Yep.
Was there injuries from it? Is there damages from it? So when we think about these things in terms of, someone coming in your home to burglarize it and they get injured, well, at least in Georgia, you owe absolutely no legal duty to a trespasser except for that wanton...
Willful and wanton conduct.
Willful and wanton malicious injury to that person. So the man trap or the shotgun going off when they break in would be that willful and wanton conduct.
Gotcha.
If they tripped on because your stairs were broken,
yeah,
sorry, you owe no duty to them
No,
to
you didn't have to
warn them
warn
or
them.
to repair it, or anything
Yeah.
like that.
I gotcha. That makes sense.
The law actually makes a lot more sense than people realize, because you do get these broad. I mean, we always go back to the McDonald's case, and I've talked about it. If you don't know it, please look up and actually understand what happened in the McDonald's case. But you just get these sound bites, just like anything political. You get these sound bites, and they're just not true.
They're used to shock the conscience and make everybody upset, make everybody think one way or another.
Yep.
Yep. All right.
Got time for one more. What we got?
Oh, just for one more?
I think that's all we got.
Okay.
We might be able to do two.
No,
It just depends on what it is. What are
Okay.
you really
Well,
curious about?
Yeah.
No, it's not me. This was like I did my research. I found like what people were
Okay.
commonly
Okay.
inquiring about. But I do have one little other thing I want to talk about. So I think this will be pretty easy though. You can't be charged with a DUI or public intoxication if you are on if you are on private property.
That is absolutely incorrect.
This is the one answer that we can say. No, it doesn't have to say yes or not yes.
Do you know
This one's
all
no.
the ones though? This is where like the notes about this one were that they're like, this one we don't understand why people are so confused about it, but literally like lawyers and police officers have argued about this.
Sure.
Is what this
Sure.
what I saw.
I mean,
said.
and obviously it
And
depends
it's
on
a state.
It depends on what state you're in.
Yeah, okay.
In Georgia, there are only a handful of laws that apply to vehicular traffic on private property. So if we're in the Walmart parking lot and you back into my car, or I pull out in front of you, you run into me, there's no laws that apply to that. That's going to be they're not even going to do an actual accident report.
Yep.
They'll do maybe a miscellaneous report that says this is what happened, this is what she said, this is what he said. But there's no failure to yield in a parking lot type thing. Those laws don't apply. What does apply is the very, very serious offenses. DUI, reckless driving, vehicular homicide, things like that. Those particular
serious injury by
serious
vehicle,
injury by
all that.
vehicle. So, but DUI is absolutely one that can be enforced on private property or on the highways and roads of the state of Georgia. Other states, I don't know, what they do. I'm sure South Carolina is the same, that you could definitely be charged at least with those particular severe type motor vehicle infractions if it was on private property, but definitely in Georgia. But we get a lot of cases. I've gotten cases where we've had them dismissed because they were, person backs into somebody at the Walmart parking lot, police show up, run their license as a suspended license.
Yep.
Well, you don't have to have a driver's license to drive a vehicle in the Walmart parking lot. You just don't. So unless that person made statements that incriminated themselves, like, oh,
I just came off the highway.
Yeah, I turned in here and was pulling, in. Well, that might say that, yes, you were driving on a suspended license on the road, but absent that type of information, we get those cases kicked all the time.
Interesting.
I got nothing. Nothing for you.
Well, I think the answer was the final answer there. It's yes or
no.
Not
It's
yes?
not. That's the first
definitive?
one. That is a definitive. No, well, I get like Shawn said. I mean, there's a certain situations the license. So yes and not yes. We can still stay with it. Yes.
Well,
and
that's
yes.
the at least
like the big battle. I think in that situation is then what do you classify as motor vehicle, and that's changing with electrical stuff, and obviously electrical vehicles are, but you have different bicycles that have manpower mixed with electric power. Is that a vehicle? That's kind of where your argument's starting to go there on your own like personal property. And if you are DUI and you're driving a bike, but you're pedaling it, and then sometimes you're using gas or whatever. Like, where's the line on that? So there's some fights in the case law regarding that kind of stuff,
and especially about golf carts and things like that.
Right.
I mean, you live in a neighborhood where a lot of people use golf carts. It's a private neighborhood with private roads, but the traffic laws are allowed to be enforced through an agreement. But there's other neighborhoods that are not private; they're county roads, but they're still just as many people using golf carts. And we get a lot of calls about that. My 19-year-old, they gave him a DUI for being on a golf cart. And we have to explain to him, well, he's driving a vehicle.
That's a vehicle. Whether you like it or
not,
it's a vehicle.
of the state. And they're probably lucky that they didn't write him a bunch of other tickets. Besides that, but something to keep in mind.
Yeah, and it is strange how the rules can change on just being on what kind of road you're on. It's not all of them, but there's some little differences of what can take place just depending on where you are. All right.
Well, to wrap things up, I think this is a fun one.
Okay.
This is not a myth. This is just, I think when we think about misconceptions and myths, a lot of these things come from watching TV or watching movies, etc. So what are like the pet peeves or things that you guys see on lawyer
Shawn,
shows?
we're going to have to really slow this down because we
aggravate
could speak for, I don't know, 2-3
days.
hours. We're going to have to go pick the top one, top whatever.
I mean, I would say that the two things that I not despise, but just
despise will be good.
That people think it's how life happens is, number one, how fast these cases, in a hour-long television drama, documentary, whatever you want to call it, they go from the crime happening, or the incident happening, to the investigation, to they're in court and there's a resolution all in this hour.
But I mean the hour, but even their time frame may be a week. That's at most.
Oh yeah.
And the actual time frame in that shows, whatever, lifeline, whatever.
When we know most of these cases
years.
that are actually going to a trial, it's going to be 2, 3, 4 years type thing. The second thing I would say is that they, in terms of like actual procedure, they do the television shows are made for drama, and these attorneys or actors that are playing attorneys, get up and talk to the judge and explain things to the judge, explain things to the jury. During an examination of a witness, that's not how it works. I mean, the only time you get to really talk as an attorney is during your opening statement, during your closing. Obviously you can object to things, but you can't ask the question, was the light green? And you say, yes, the light was green. And then turn to the jury and say, see, the light was green. And the reason my client went through it was because the light was green, which means the other light had to be red. You just, you see a lot of things like that there's very limited.
But it's also because they're trying to break it down, and you're trying to tell the story to the audience too, right? On TV and
Sure.
movies, right?
We
So there's a
understand
little
why,
bit of that
but it
that has
just
to happen.
it drives me crazy.
But then when people actually, I mostly hear it from jurors, because they're the people that actually
Because then they end up in a courtroom and they're like, wait a
they
minute.
get to witness trials. Not many people just go to the courthouse just to watch trials unless they're involved, thinking about going to law school or serving community service, or they're, summoned for jury duty, and by law they have to. So the juries get to learn that trials, can be fairly dry, fairly boring, because some witnesses we call are not interesting whatsoever, but you have to establish particular facts, particular things in order to meet, the legal standard in a case.
To give you an example, Shawn, like you said, that legal standard, you got 5 things you got to hit. And your case is really all dependent on number 5, whatever it is. That's really the fight. And it's really boring to the jurors, but you have to go through 1, 2, 3, and 4.
Sure.
And if you don't, what happens is, so you just everybody might agree on all that, both parties, right? But if you don't do that, you do the greatest case in the world on number 5. You do it awesome, and then you sit down, and then they stand up and go, well, we're just going to kick this out because he didn't meet the other parts, and the case is over.
Sure.
Like, so you got to do all this boring stuff. It just is.
Yeah, you either have to do the boring stuff or, especially in civil litigation, and we try to do it, most of the time in criminal cases, is you want to meet with the other side, and you want to neither side wants a jury that is bored out of their mind.
Right.
So if we can get together and say, we all agree that this person that died is a human being. Well, that's something you would have to prove.
Yeah, you have to actually
That's what you would have to prove
Yeah.
in a murder as a prosecutor. We could do a stipulation so that they don't have to ask that dumb question of the medical examiner.
Because then the juror's probably thinking, what kind of
They do.
idiot?
Exactly.
I've said it a ton on this
question?
podcast, but there's so many times that people think attorneys are dumb because the questions they ask. We have to ask these dumb questions.
Yeah.
That's a big problem.
Well, and there's foundation questions for certain pieces of evidence that can get really repetitive.
And
say
boring.
you have a case that you have 100 pictures that you want to admit. And you get with the other side and you say, well, this is my evidence. Can we agree that these are going to be admitted? If you do that, well, then you don't have to go through the question on every single one. Is this a fair and accurate representation of the way that you saw it that day? Has it been altered or deleted? Has it been, you can just say.
You have to do that every picture.
Yeah. And I've been in cases where, the prosecutor had 20 or 30 photographs, and I agreed. These are all in. We're stipulating that these are admitted into evidence. And then they still went through the entire process.
What are we
with
doing here?
Like,
That kind of does lead to one of my pet peeves is the animosity between counsels and shows I'm not saying all attorneys get along, but for the most part, you're not hating the guy or the girl across from you. I mean, they're doing their job.
Not
You're doing
everything.
your
It's not
job.
good versus evil.
No, it's not. And then even after the case, I mean, a lot of times we'll go to dinner together, talk about, I thought y'all did good on this part. Y'all did good on this part. It's just not. It's adversarial when you're in there, but it's not hostile, right?
Yeah.
And a lot of law is not hostile. People think of this just. They think a good lawyer is somebody who screams and shouts,
cutthroat.
Cutthroat. That's not how you get anything done. That's a bad lawyer. If your lawyer's screaming and shouting all the time, then he's not listening to the facts and trying to figure out what's best for you. That aggravates me to no end on TV shows. The other one for me, Shawn, is the expertise of the lawyer in all legal fields. I watched this one show. My wife watches it. I don't know the name of it. It's a mom and her son is the investigator. The mom is the big-time attorney. The son had gotten into trouble for something, but now he's an investigator. And I've seen a couple of them. Something like Fred, Good Time Fred. I don't know. Forgive me.
It's like,
whatever.
don't hold me. Don't hold. Oh.
I don't know. Don't count on me. I don't know. Whatever it is.
Yeah.
I know what show you're talking about. I have no idea what the name is.
Somebody's going to just have to tell us in the comments.
Yeah, it was fine. It was a fine show. It was kind of entertaining, fun, but she's like, doing this mass tort claim where she's the only attorney and she resolves it within like a 2-week period.
Then a discrimination claim the next week.
The next one was she was defending a murder against someone, and then it was this huge gang thing. It was a RICO case that she was doing by herself. And then the next one, she was doing a big divorce. I'm going, that's just not possible. The legal field used to be, especially, smaller towns. I grew up in a small town, and even it's not that way now. I don't think any town is. You don't have a general practitioner. You don't have a general lawyer anymore. Like, you can't go to, back before the internet and everything else, you could go to the local lawyer and he would do your will or your personal injury or your criminal case or whatever you needed. If you do that now, then you're not getting good representation. And
like, I can't sit here and ask y'all myths about trademark law.
Right.
Be like, I don't know.
I can tell you stuff on all law because I have a general knowledge, but I don't know the ins and outs of every single little type of law. And if you actually have a case, you need to go to somebody who specializes in that part of the law. You just do. So that's my pet peeve.
The only way to be very, very proficient at something is to specialize in it, to continuously be researching the new changes in the law in it and how things are done. And it's just too difficult to say.
I don't think it's too difficult. Okay. I think it's impossible.
Well, no,
you can't be it. You can't.
Okay, well, yeah, I'll figure out how to. If I was to do your will or set up an estate for you,
you could do it.
I could do it, but it would take me 2 weeks to figure out how to do it.
It cost me twice as much.
Correct.
Because you have to do the research to figure out how to do it when somebody else already knew
Instead, I can say, that's not what I do.
Right.
Here's a guy or girl that does it, and they can do it in an hour.
Right.
Yep.
Yeah.
So that, the one attorney that kind of bounces around and is the expert in all fields and settles those cases in a week. I mean, it's fun to watch, but that aggravates me.
She's just a special litigator.
She's just so special. It's just, amazing what they do. So.
That's great. Well, I think if then any other legal myths that people want to have debunked that we didn't cover today, they can drop them in the comments.
And also, give us a thumbs up if we keep Lindsey and kick Chace out. I mean,
it's a fair question.
It's a fair question.
I mean,
yeah. Well, I'm just upset.
She didn't try to convince us of mandatory military service.
That's
at least.
True. That's true. People think about that.
Yeah, I'm not a fan of that. So I wouldn't like that. But I'm happy to be a special guest anytime. I was happy to fill in for Chace.
Well, you did a great job, and we certainly appreciate it. I hope everybody is recovering from the hurricane, and hopefully another one's not going to hit us too bad. Like and subscribe, and we will be back shortly. Thank you for watching. We'll see you next time.